This video is presented by the Office of Ohio Attorney General Mike DeWine and was made possible in part by a grant from the Ohio State Bar Foundation. The views expressed herein do not necessarily represent those of the Ohio State Bar Foundation. Please be aware that Ohio's Public Records and Open Meetings Acts are both self-help laws which the Attorney General's Office has no authority to enforce. The content presented in this video is for informational purposes only. For specific legal advice, please contact your legal counsel. The Ohio Revised Code defines public records as records kept by a public office. The terms records, kept by, and public office have specific legal definitions that we will discuss in this presentation. To meet the definition of a record, a particular item must meet all three prongs under the following test. To be a record, information must be stored on a fixed medium, created, received by, or come under the jurisdiction of a public office, and documented to explain the organization, functions, policies, decisions, procedures, operations, or other activities of the office. We will now review each of these elements in some detail. The first prong of this test requires that information must be kept on a fixed medium to be a record. This can include CDs, Excel spreadsheets, or any other form of storage. As long as the information is stored in some way that it can be later recovered, this first requirement is met. This slide displays examples of items on which information can be stored, including cassette tapes, emails, and pictures. However, if information is not stored on a fixed medium, this information would not be considered a record, but would instead be considered a non-record. For example, a conversation between two people that is not recorded or documented in some way does not satisfy this first requirement because there is no recording of this conversation. As another example, if a public office receives a public records request for a list of all cases that the public office is handling, and the public office does not maintain such a list, the requested list is not in existence, and as a result, there is no record that is responsive to the request. A public office has no duty to create such a list if one does not exist at the time the request is made. The second prong of this test requires that the record must be created by, received by, or come under the jurisdiction of a public office. While it may be easy to determine whether items are created or received by a public office, it may be more difficult to determine whether a particular item comes under the jurisdiction of a public office, because it may be held by another entity that is performing a public function for a public office. This concept will be explained in greater detail during our discussion of the definition of public office. Finally, the third prong of this test requires that the record document the organization, functions, policies, decisions, procedures, operations, or other activities of the public office. Under this prong, it is necessary to look at the content of the record rather than at the location or format that it is kept in to determine whether a particular item is a record. While some may assume that all paper and digital items in the possession of a public office document what the public office does, that may not necessarily be the case. For example, are spam emails that employees of a public office receive and never solicit, never respond to, or never use records? Let's analyze whether spam emails meet the definition of a record under the three-prong test. In looking at the first prong, spam emails are stored on a fixed medium, an email, so the first prong is satisfied. The question under the second prong is whether an email containing spam sent to employees of a public office was created by, received by, or comes under the jurisdiction of a public office. Again, the answer to this question is yes, because the spam email was received by employees of a public office. Finally, under the third prong, the question is whether spam emails document the activities of a public office, whether the public office actually uses the spam email to carry out its duties or responsibilities. In this particular example, the answer is no, because the employees never requested the information contained in the spam email. They never used the content of the spam email to carry out their responsibilities, and the content of the spam email does not document anything that the public office does. As a result, the third prong of this test is not met. Because the spam email does not meet all three prongs, the spam email is a non-record of the office. If, however, the employees of the public office actually used the information contained in the spam email to, for example, accept the email's offer to buy office supplies, then the public office has transformed that email from a non-record into a record by using the contents of the email to carry out their responsibilities as employees of the public office. Keep in mind that it is important to evaluate an item based on its content, the type of information contained in that record, as opposed to the location or format in which information is stored. We will now move on to discussing the second part of the definition of a public record, which is a record kept by a public office. A record is a public record only if it is kept by a public office. That means that at the time the request is made, a record must actually be in the possession or control of the public office under the terms of its records retention schedule for such records. Records that are not yet in existence or which are in existence but have not been received or come under the control of the public office are not public records. At the end of the period that a public office keeps a record, it disposes of it pursuant to the appropriate records retention schedule. When a record is properly disposed of under the records retention schedule, it is no longer being kept and is therefore no longer a public record subject to the Public Records Act. Finally, to be a public record, the record must be kept by a public office. A public office is everything we typically think of as the government and includes any state agency, political subdivision, or other organized body, office, agency, institution, or entity established by the laws of this state for the exercise of any function of government. Sometimes records held by private entities may also fall under the jurisdiction of a public office. Specifically, courts have extended the definition of a public office to include private entities that are the functional equivalent of a public office. Under this test, courts consider 4 factors: whether the private entity performs a government function, the level of government funding, the extent of government involvement or regulation, and whether the entity was created by the government or to avoid the requirements of the Public Records Act. Courts weigh these factors to determine if there is clear and convincing evidence that a private entity is the functional equivalent of a public office that is subject to the Public Records Act. In addition, when a public office contracts with a private entity to perform government work, the resulting records may be public records. Courts analyze 3 factors to determine whether records held by a private entity that contracts with the government to perform government work are public records, including whether the private entity prepared the records to perform responsibilities normally belonging to the public office, whether the public office is able to monitor the private entity's performance, and whether the public office may access the records itself. For more information on this topic, please consult the Attorney General's Sunshine Laws Manual, which can be found on the Attorney General's website. We hope this video was helpful to you. Please use the provided link to complete a brief survey regarding this training. We appreciate your feedback. This video is presented by the Office of Ohio Attorney General Mike DeWine and was made possible in part by a grant from the Ohio State Bar Foundation. The views expressed herein do not necessarily represent those of the Ohio State Bar Foundation. Please be aware that Ohio's Public Records and Open Meetings Acts are both self-help laws which the Attorney General's Office has no authority to enforce. The content presented in this video is for informational purposes only. For specific legal advice, please contact your legal counsel. The Ohio Public Records Act ensures that the records of public offices in Ohio are available to any person who requests them. To examine the records of a public office, the first step is to make a request for the public records you would like to view. This video will cover your rights and also your obligations under the Ohio Public Records Act as a public records requester. It will also provide some helpful information and resources to make sure you receive the records you are looking for as quickly as possible. There are a few points to keep in mind when composing your public records request. First, a proper public records request is one that asks for records that actually exist at the time that the request is made. This means, for example, that a public office is not obligated to provide records that have been properly destroyed after their retention period has expired. This also means that a public office does not have to provide you with information that does not already exist in a record. For example, if you ask a public office for a list of court cases pending against it, but the office does not already keep a list containing that information, the public office does not have to create such a list in order to respond to your request. This makes the Ohio Public Records Act a bit different from the federal Sunshine Law, the Freedom of Information Act, or FOIA. The Freedom of Information Act is a law that gives you the right to access information from the federal government. The Ohio Public Records Act applies to Ohio public offices and requires you to make a request for records as opposed to information. Finally, a public office does not have to provide you with records that have not yet been created, even if they will someday be created. Second, the public office needs to be able to understand what sort of records you are looking for. To this end, the Ohio Supreme Court has said that a request must be made with reasonable clarity. That way, the public office can identify and locate any records it has that are responsive to your request. The public office must also be able to identify the records you're looking for based on the way the office ordinarily maintains and accesses its records. For example, if your request is too ambiguous or too vague, a public office may not be able to figure out what records you are looking for. Also, if your request asks for a very large volume of records, a court may find it to be overly broad and decide that the public office does not have to respond. An example of an overly broad request might be all emails created by the Attorney General's office since 2006. This request could potentially involve hundreds of thousands, if not millions, of documents, and is not the way the Attorney General's office organizes and keeps its emails. The Attorney General's office generally keeps its email correspondence organized according to subject matter or case file. So, a request like all correspondence, including email maintained in the file for case Smith versus Jones, is a more narrow request and corresponds to the way that the Attorney General's office organizes its email records. Public offices are required to create retention schedules for all of the records they create. These retention schedules are an excellent resource to help you formulate your public records request because they can give you information about how an office organizes and maintains its records. Retention schedules for state agencies can be found online. You might need to inquire with local agencies to review their retention schedules. In short, your public records request must be reasonably clear so that the public office can identify and locate any records that respond to your request. There is often a practical benefit to composing specific, narrowly tailored requests. It allows the public office to more quickly and efficiently find the records you wish to see. This helps both you and the public office. Next, let's review some of the rights you have as a public records requester. First, your identity. Anyone can make a public records request. A citizen of another state, a non-U.S. citizen, a corporation, a minor, another government entity, etc. Also, you do not have to disclose your identity to make a public records request. You may make a request completely anonymously. Second, your request. You do not have to make a request in writing. You may make a request verbally, in person, over the phone, by email, by fax, or by any other method of communication. You also do not have to use magic words or refer to the public records law, as long as the person you are communicating with can determine that you are making a public records request. You have made a valid public records request under the law. Third, how you get the records. You have two choices when making a public records request. You can either receive the records by copies, or you can choose to come into the public office to view the records in person. If you choose to receive copies, you have several options. 1, you can choose to receive paper copies. 2, you can choose to receive copies in the form in which the public office keeps them. If the office keeps the records on paper, for example, then you would receive the copies on paper. 3rd, you can choose to receive the copies in any other form that the public office determines is reasonably available. For example, you might request to receive an electronic version of paper documents if the office determines that this is reasonably available. The public office can charge you the actual cost of making the copies and sending them to you. Be aware that this cost cannot include employee time spent gathering the documents and making the copies. Rather, the charges can only include the actual costs of copying and mailing. That is, the paper, ink, toner, etc. used to make the copies, and the actual cost of shipping the records. You may also choose to pick up the records at the public office. The office can also require payment up front before it releases the copies to you. Finally, timing. If you choose copies, the public office has a reasonable amount of time to provide them. Please note that you do not have the right to give the public office a deadline for providing the copies. The office is allowed time to locate the records, review them, make any copies or redactions, and consult with their legal counsel, all while attending to their regular job duties. Depending on the size and complexity of a request, the reasonable time to complete all of these tasks may take days, weeks, or even months. If you choose to view the records in person, the public office must provide them promptly. Be aware that prompt also includes the time it takes to locate the records, review them, make any copies or redactions, and consult with legal counsel. Even if you arrive in person to make a request to view public records, the office is allowed to take the time to complete all these tasks. You might not be able to view the files you request on the same day. You will have to come into the office during regular business hours to view records. The public office does not have to provide special hours so you can view documents at your convenience. Also, if you view records in person, the public office cannot charge you any fees. A good place to start for information about charges for copies and viewing hours is the office's public records policy. Every public office in Ohio is required to have a policy and post it in their office. Many offices also post their policy online. You can find the Attorney General's policy on our website. The public records policy will give you information about how that office handles public records requests. We've been discussing your rights and obligations under the law, but here are a few practical pointers to help smooth the process. Find the right public office. You may want to call around first so you don't waste time corresponding with an office that doesn't keep the records you want. Prepare. Review your rights and responsibilities under the law. The Attorney General's office provides many helpful resources. Be as specific as possible when making your request. The more specific and narrow your request, the less time it should take for the office to respond. Use the public office's website and retention schedules to help you get a better sense about how to formulate your request. Ask for the records you really want to see. You can always make an additional request later if necessary. Finally, be willing to negotiate and revise your request. It may help to share why you want the records or to ask the office, what would you recommend? Build a good relationship with the public office. A cordial relationship helps the process run smoothly from both sides. Be clear about how you would like to correspond with the public office. Provide your correct contact information and follow up reasonably if the response seems delayed. Let the public office know if you want to be notified of any costs for copies. Although you are not required to, make your request and follow up communication in writing. This helps to reduce any misunderstanding later about exactly what you asked for. For more information on this topic, please consult the Attorney General's Sunshine Laws Manual, which can be found on the Attorney General's website. We hope this video was helpful to you. Please use the provided link to complete a brief survey regarding this training. We appreciate your feedback. This video is presented by the Office of Ohio Attorney General Mike DeWine and was made possible in part by a grant from the Ohio State Bar Foundation. The views expressed herein do not necessarily represent those of the Ohio State Bar Foundation. Please be aware that Ohio's Public Records and Open Meetings Acts are both self-help laws which the Attorney General's Office has no authority to enforce. The content presented in this video is for informational purposes only. For specific legal advice, please contact your legal counsel. What happens if a person believes a public body violated Ohio's sunshine laws? Both Ohio's Public Records Act and Ohio's Open Meetings Act are self-help statutes. Self-help statutes require citizens to enforce laws themselves. If an individual believes that an agency has failed to comply with Ohio's sunshine laws, that individual may file a lawsuit, either on his or her own, or with the assistance of a private attorney. The Ohio Attorney General's Office cannot provide legal assistance with this lawsuit and does not have enforcement power to make an agency comply with Ohio's sunshine laws. The statutory remedies are different for alleged violations of the Public Records Act and the Open Meetings Act. An aggrieved person, the person who made the public records request, who believes that an agency has failed to provide records as required under the Public Records Act, can file a mandamus action in the Common Pleas Court where the alleged violation occurred, in the Court of Appeals in the Appellate District where the alleged violation occurred, or directly in the Ohio Supreme Court. The Supreme Court and many appellate courts and common pleas courts have mediation programs available if the court or the parties wish to use them before going further in the lawsuit. For an individual to win the mandamus action, an individual must show that they had a clear legal right to records, or better timeliness, or some other legal right under Division B of the Public Records Act, and that the agency had a clear legal duty to satisfy the requester's right. If the requester wins the lawsuit, the court can order the agency to produce records, pay the court costs, and pay the requester's reasonable attorney fees. Reasonable attorney fees means fees actually incurred by the requester in hiring an attorney for the court litigation of the public records dispute. In certain circumstances, the court can also order the agency to pay statutory damages. To be eligible for statutory damages, the requester must have transmitted a written public records request by hand delivery or certified mail, and must have fairly described the public records or class of public records to the agency. The Public Records Act explains that these damages are not a penalty, but are instead meant as compensation for injury arising from lost use of the requested information. So, statutory damages will only be awarded where the violation of the Public Records Act resulted in lost use of the requested records to the requester. The statutory damages are $100 per day for each business day after the filing of the mandamus action seeking statutory damages, up to a maximum of $1,000. Even if an initial award of attorney fees and/or statutory damages is made, the court may reduce or eliminate these awards if the court determines that a person well informed on public records law would reasonably believe that the office's conduct did not constitute a failure to comply with the Public Records Act or the public policy behind the Public Records Act. The Ohio Attorney General's Office encourages individuals and public agencies to contact the Attorney General's Mediation Program regarding a public records dispute before a lawsuit is filed. More information on that program can be found on the Ohio Attorney General's Office's website or in the online tutorial about the mediation program. What about when an individual believes they've spotted a violation of the Open Meetings Act? Like the Public Records Act, the Open Meetings Act leaves it to individuals to file lawsuits concerning alleged violations. If any person believes that the Open Meetings Act has been violated, that person may file an injunction action, which, if granted, will compel the members of the public body to comply with the law. Unlike actions involving the Public Records Act, a lawsuit regarding Open Meetings Act allegations may only be filed in the Court of Common Pleas where the meeting at issue took place and must be filed within 2 years of the alleged violation. Separately, a person may file a mandamus action to compel the creation of or access to meeting minutes or to seek a request for a public body to be ordered to give notice of meetings to the person filing the action. Because the Open Meetings Act requires that any official action of a public body be taken in an open meeting, formal official actions adopted by other means are invalid. Also, if the formal action is adopted in an open meeting, but was a result of closed-door or private deliberations, the formal action is also invalid, unless the deliberations were on a topic specifically allowed to be addressed in executive session. You can learn more about these exceptions in the AGO's online tutorial about executive sessions. If the person is successful in showing a violation of the Open Meetings Act, the court will issue an injunction compelling the members of the public body to comply with the law, such as ordering the body to refrain from prohibited behavior. The injunction may include invalidating any formal action taken in violation of the Open Meetings Act. A member of a public body who knowingly violates an injunction issued in an open meetings case may be removed from office by an action brought in the Court of Common Pleas by the prosecuting attorney or the Attorney General. If the court issues the injunction, the court shall order the public body to pay a forfeiture of $500 to the party that filed the action. If the court issues the injunction, it shall also award to the filing party all court costs and the party's reasonable attorney's fees. Like the awards under the Public Records Act, the court may reduce the amount of the attorney's fees if the court determines that a person well informed on public records law would reasonably believe that the office's conduct did not constitute a violation of the Open Meetings Act or the public policy behind the Open Meetings Act. However, and unlike the remedies under the Public Records Act, if the court does not issue an injunction in an open meetings case, and the court determines that the bringing of the action was frivolous conduct, the court will order the party that filed the action to pay all court costs, as well as the public body's reasonable attorney fees. For more information on this topic, please consult the Attorney General's Sunshine Laws Manual, which can be found on the Attorney General's website. We hope this video was helpful to you. Please use the provided link to complete a brief survey regarding this training. We appreciate your feedback.